Hi there, I'm Savannah Mextro with Mannor Law Group, and I'm excited to welcome you to another Webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. If you can't make it to the movies, well, it's no problem because today, attorney Bob Mannor is bringing the movies to you. Today's webinar will shed light on the top 3 most famous estate planning movie myths you probably believe. Now, before I pass the torch to Bob, I'd like to cover a few housekeeping details. First, a disclaimer. Now, today's webinar is going to be informative, educational. You will definitely learn something new, but you're not going to receive specific legal advice. I encourage you, if you are looking for some advice or just something about your unique situation, to contact us after the webinar. Also note that today's webinar is recorded. Tomorrow, you will get a replay of the webinar today. So be sure to look out for that tomorrow and share that with family and friends. Now, if you have questions during today's webinar, I encourage you to put those questions in the chat box. We will save time at the end of today's webinar to review those questions, and Bob will shed light on some answers for you. Now, if for some reason we don't get to your question, we will contact you after the webinar. Now, why should you listen to what the folks at Mannor Law Group have to say? We're a nationally recognized and respected elder law and estate planning firm. All 3 of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney with the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. He's currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, my personal favorite reason, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Mannor.
All right, folks, this is going to be a fun one. So we're getting a little lighter here with Webinar Wednesday and just decided to have a little fun today. And so that is, I could not limit it to the 3, though. We decided the top 3 myths. I have a lot more than 3 because I couldn't limit it to 3. So, but we're gonna have a little bit of fun, but also it is actually instructional. Some of the movies, it's really interesting. And so there's one in particular that's kind of fun that talks about this abstract arcane law that we had to study in law school. So I threw that one in because it's kind of a fun reminder of law school. But there are a few things we can learn from those movies, and you know, a lot of the things that we do, we end up we feel like we're you know, learning things from the movies, and really they can have an impact on, you know, the society and culture and the way that we think about things. And the first myth is going to be that, of course, like Savannah said, none of this is going to be specific legal advice to you. We're going to be talking about some basic issues, but it's if you're getting legal advice from the movies or legal advice that's not specific to you, that's a bad idea, of course. But we'll have a little bit of fun and go through a few of these. And this is probably the most persistent myth of all, and that is the reading of the will. Okay, so it seems like every movie, I just picked out 3 of them, in Rain Man, Gran Torino, and the Grand Budapest Hotel. But it seems like I see this all the time in movies, is about, they have, you know, somebody dies, and the important thing that happens is everybody, the family has to all gather and meet at the attorney's office, and then they read the will, and everybody goes home with their bag full of cash or the car keys or whatever it is. And of course, that's not the way it works at all. In fact, there's almost never a reading of the will. That doesn't happen. And certainly we're not going to gather all the heirs or beneficiaries in a room after the death and start handing stuff out. There's actually a pretty, you know, thorough process that you have to go through, and you should go through when someone dies, to make sure that whoever's in charge of it actually doesn't end up in a situation where they're liable, or that they're liable for debts, or that there's fights, or there's arguments, or that people can come back and complain later. We got to go through this process, right? So in Gran Torino, I remember the big issue was this vehicle, right, the Gran Torino, and the controversy was at the end that he gave it to somebody he wasn't related to, and that was the big end of the movie. Well, that might, obviously you can leave things to anybody you want, but the point of it was there would not have been a meeting where all the relatives and non-relatives would have been gathered in this law office, and this old lawyer with spectacles starts reading the will and handing out car keys. That doesn't happen. There's going to be a whole process that we go through. The law actually requires publication if we want to limit liabilities, so we have to publish. Even if it's a trust, we still want to publish to go through that. There's a waiting period after the publication. There's a process for making sure that the person in charge isn't liable for anything. And so if we don't follow that process, so typically what happens in our office, what we'll often do is we'll say that if everybody's getting along, that at least at the beginning, if everybody's getting along and the person who's in charge, the executor or the successor trustee, sometimes they call it the personal representative, if everybody's getting along, then we will, it's up to the executor, but the executor can choose to invite other family members to come to that meeting. We do not read the will. We presume you have read the will before we got there, right? It's not, we don't hold the will, the client would hold the will. So you would have presumably read that, or the trust or whatever. And sometimes a lot of the will or the trust is actually not all that interesting to the heirs, because the bulk of the words in there is about the legal technical part of it and not about who gets what and who gets the Gran Torino. At that point, then what we'd end up doing is going through this process. We explain the process at that first meeting, but nothing gets handed out. We shouldn't be distributing anything until we've done the publication, until we've taken care of the liabilities, make sure that the person in charge, the executor, isn't going to be on the hook for anything that comes up in the future. And so that's what that process is all about. And so nobody gets the car keys that day. That meeting is typically just an explanation of what that process is going to look like. And then at some point later, hopefully quickly, and that's how one of the things we do is help people go through this process, very efficiently and quickly, but they will then get the car keys at some later date. And we do have a rule in our office that we ask the question, is anybody fighting? Is anybody arguing? And if anybody's arguing, if anybody's fighting, if we think they're going to fight, if we think there's going to be a problem, then we say, nope, the only people that can come to the meeting are going to be the executor or the successor trustee. Why would we say no other family members except the person in charge if we think there might be an argument about it? Now, I would like to try to tamp down that argument, but the problem that comes up is then the person who's arguing, that other relative, may think that the lawyer is there to represent them also. And the lawyer's not there to represent any heir. The lawyer is not there, at least when we're dealing with it. We drafted the plan, and they're coming into us for help to administer that will or trust. We represent the interests of the deceased, right? And we have to represent the interest of the person put in charge of it in their capacity as being in charge of it. And what I mean by that is, let's say there's 3 kids, and Johnny is the one that mom and dad picked as the executor. We don't represent Johnny and Johnny's interests. We can't favor Johnny in any way. What our job is to make sure that Johnny doesn't get sued, that Johnny doesn't have any extra liabilities for taking on this role as executor, and that the terms are followed. And so we technically would represent Johnny if we're hired to assist with this process. But our goal is to make sure that the original intent was followed, and that Johnny doesn't get sued, and Johnny doesn't get, and along the way, we're going to try to tamp down any fights or arguments or things like that. But I never want other people in the room to think that it's my job to represent their interests, which it's not. We can't be. That would be a conflict of interest, right? So it's really important. Unfortunately, there's a lot of things when it comes to lawyers that we've got to follow all these strict ethics rules. And so we typically would not, for that meeting, we typically, if we think that there's going to be some controversy about the neighbor or the friend getting the Gran Torino, we probably wouldn't invite the neighbor or the friend. We'd be talking to them later and saying, okay, here's the process and here's what, here's what to expect. But we wouldn't want them, because we wouldn't want them to think that they were being represented by us. And lawyers have all these rules. Sometimes it seems strange to folks about conflicts of interest and attorney-client privilege and all that kind of stuff. And so the bottom line is there's no reading of the will ever. There's never a reading of the will, and people don't get they're not going to receive those assets on the first day. So that's probably the most persistent myth that almost everybody believes. Everybody believes, okay, mom or dad died, we got to go to the lawyer for the reading of the will. I've never seen that once ever happen. It doesn't happen. I've never heard of that happening in real life. It makes for good movies, because then it's this dramatic thing that, oh, who gets the Gran Torino, So, all right. What else? Oh, this is interesting. This is kind of an obscure movie. I don't think I've seen this one. But the myth of an oral will. So I'm sure that I've seen other movies where this was a thing. I was talking to somebody the other day, and they kept saying, well, this is the way it's going to go. So they said, my spouse will be able to live in the house until, if I die first, my spouse will be able to live in the house. And then after that, this is what's going to happen. And if they want to sell the house, this is what's going to happen. And I had to tell them, no, none of that is true, because that's not what your legal documents said. We had not prepared the legal documents. They were having me, they came to me to review their existing legal documents, and I said, no, that's not true. And she said, well, it is, because I just said it, right? It's true. Well, that's apparently what happened in this Buried movie, that this guy maybe had a cell phone or something like that, and or maybe a piece of paper, and he was buried alive or something like that. And the idea was, I guess it wasn't a piece of paper, because it would have been oral. You can actually have a piece of paper that does this, but you can't have it as a completely oral will. There is no such thing, because how do you prove it? You can't even have, we see this on movies, sometimes you'll have that, video will, and typically in the movies, it's always that the grumpy old man is using the video to complain about his family or whatever. You can have a video that goes along with the will. Sure, you can have a video that you leave it, but that's probably not going to be a legally binding document, that video. That might just be, and I've actually seen that where people will record something, or maybe they'll record the signing of the will, or they'll record just a message. I've seen that happen in real life. That's not a will. At least in Michigan, it's not. That wouldn't qualify as a will. So if you're planning on, of course, nobody on this phone call would do that, but if you're planning on waiting until your last breath, and that you think that you'll be able to just verbally state your wishes, doesn't work that way. That's not legally enforceable. It's not going to be binding. This is another one. I've seen this in different movies, but this was an example of it in Superman Returns. Lex Luthor. If you're a Superman fan, you would know who Lex Luthor is. Lex Luthor forces an old lady to sign a will on her deathbed, and then immediately dies, and then he inherits all of this. Well, I didn't put this as a myth so much as because, could that happen? Sure. I've seen people try to get legal documents signed under undue influence when maybe the person didn't have capacity. In the way that it was done in this movie, it would not, I don't see that as a feasible thing, where he lifted her hand and wrote her signature for her, and then she immediately died. Well, okay, a will has to be, so for in Michigan, a will that's in your own handwriting could be done without witnesses. They call that a holographic will. So you can write a will, in theory, that is in your own handwriting. So it's not typed up, so not just your signature, but you literally, the whole will has to be in your handwriting, and you sign it. It doesn't require witnesses or notary. But I've seen, typically these things can be challenged, especially if this, in fact, in the movie, the person was very, very rich. Presumably they would challenge it. And the main way that you challenge these types of things would be either to say that there's probably three ways technically. The third way is that the document doesn't meet the technicalities, and Superman Returns, that document wouldn't have met the technicalities of a will or a trust. The two primary ways, though, are that you say that the person didn't have capacity to sign the will. They didn't have the legal ability to sign the will because they lacked legal capacity. But the most common thing is what they call undue influence. And undue influence is actually a fairly common argument and a common thing that people can take into court. And that's proven by a series of factors. And no one factor is going to necessarily be determinative, but you look at those factors. And the factors include things like, who arranged for the document to be signed? Who drove the person to the lawyer's office? Was the person in the lawyer's office at the time that the will was signed? Was the daughter in the room when it was signed? Was the daughter in the room when the discussion was had? Was that person in a position where they had an undue influence on the decedent, where maybe if they're a caregiver and they're dependent on them for food, they're dependent on them for getting to the bathroom, they're dependent on them for everything. That person is in a position that could result in undue influence. And so those are just some of the factors that go into whether or not it could qualify for undue influence or not. So there's an interesting case now in Michigan that it kind of goes to the same topic, and it's an outlier case. So it's on the books, but lawyers just kind of shake their heads at this, that how this got through. There was a text message that the court interpreted it as a will. And that doesn't meet any of the standards written in the law that would qualify for a will. Typically, they're pretty strict about enforcing those standards as far as what is a will and what isn't a will. And in this particular case, they said a text message constituted a will. Why do I have a problem with holographic wills and text messages as wills? Well, primarily because I've never seen one that was sufficient or complete enough. Could it be interpreted as a will? Yes, it could be enforceable. Do we want it enforced? Does the decedent want it enforced? Maybe not. In other words, they haven't thought through everything. They're not complete. They're missing things. They haven't stated all of the things that they would have wanted to state. It's not comprehensive enough. And almost every handwritten will that I've ever seen fell into that category. And another way of saying this is that, me and my staff, and especially the attorneys here, we think about making sure that everything's in there and that it's complete and comprehensive. We think about this every day, at least 5 days a week, for years and years and years. Whereas somebody that's writing a will and they sit down on it with a piece of paper and pencil and they say, okay, well, let me think this through. They may give it a few hours of thought. We've given it years and years of thought of what needs to be in there. And we've read the statutes and we've read the law. And so really smart people have tried to write handwritten wills, and it was not comprehensive enough. It was missing things. It was sometimes internally inconsistent, not the way that maybe an average person would read it, but there's ways that the courts interpret, or the way that the law or statutes interpret it, made it internally inconsistent. And so bad idea to write your own will. There is a thing called the Michigan statutory will, where it's kind of a fill in the blank will. It's better. If you're going to do that, I wouldn't recommend it, but it's probably better than doing a handwritten will. Now, the statutory will does have to be witnessed and or notarized, but no, actually witnessed it needs two witnesses. Even if it had a notary, it still needs two witnesses. That's the standard in Michigan. Okay. This was interesting. And Shawshank Redemption is not really about wills and trusts or inheritances, but there is a portion in it where the character played by Tim Robbins ingratiates himself to the guard, the corrupt guard, by giving him instructions as to how to avoid paying taxes on an inheritance that he was going to get. And so a lot of people just assume if you die, and leave anything to your kids, you're going to pay taxes on it. In reality is that's not the case. There are no inheritance taxes or death taxes in Michigan. And on the federal level, you don't have to worry about death taxes or state taxes or inheritance taxes. You don't have to worry about that until you get up into the, it's currently at $20 million. No, well, actually, it'd be $11 million, but you can double it if you're married. And so for most of us, we're never going to have to worry about the estate tax. Of course, if you've been on some of my webinars, you know that this is a big topic right now. Of course, the issue of taxes is not completely something you don't have to think about, because the big issue on taxes right now would be your retirement accounts. So your IRAs, 401ks, qualified annuities, any kind of retirement account, those are the ones that we're going to have to worry about taxes. And the reason why it seems inconsistent what I just said is worry about taxes, but don't worry about taxes. It's a different tax, right? The inheritance taxes, it's going to be the inheritance taxes, it's going to be the income taxes, because you never paid income taxes on those retirement accounts. And we want to be strategic about it. Or if it's a Roth, we want to be strategic about making sure that we continue to let that grow tax-free for some period of time. But the idea here is that that's not an inheritance tax. That's not a death tax. It may seem like you're paying a death tax because if you do it wrong, it could all be paid on death. Now, that's one of the things that we've talked about, had other webinars about, we really don't want to pay those taxes on death, the inheritance, the retirement account taxes on IRAs, 401ks, Roths, things like that. We don't want to end those accounts on death, and that's one of the things that we'll be contacting all of our clients about in the, we're almost got those messages out, so we'll be getting those messages out shortly. But that's where the tax comes in, and that's where we can be really strategic about making sure we pay less taxes. But it's not actually on, say, if you left somebody your house, they wouldn't pay taxes on it. So, okay. I told you he had more than 3. I couldn't narrow it down to 3. Inheritances can come with a catch. So there's a couple of movies here that are funny movies. We see this all the time in movies. This is just a couple of examples here. And that is that in The Bachelor, the rule was he had to get married by this certain date, otherwise he wouldn't get his inheritance. In Brewster's Millions, it was that he was the decedent was worried about him wasting the money and blowing the money, so he had the option of either spending $30 million within 30 days and spending all of it, wasting all of it, or he could take 300 million and not waste it. And so anyway, the bottom line is this is actually something that is true. It's tricky. So sometimes people come in and they have all these catches that they want to have, that they say, okay, well, this person needs to do this. But the most common thing would be maybe you have an heir that has had some issues with substance abuse or things like that, or gambling, and you say, okay, well, we put things in there that said, maybe they wouldn't get all the money at once. It'd be managed for them for some period of time, and they get the money over a period of time, and that they have to pass a drug test, or they have to, do this. That's one common thing. One of the ones that we've done sometimes for people that have lots of money and they wanted to share that money with their heirs, but they were worried their heirs would get lazy. If they get this big inheritance, they worried their heirs would get lazy. So some people have put in there a provision that says, you'll get this money, but you only get so much as you earned that year. So the trust is set up to say, okay, I'm going to leave this to the grandchildren, and the grandchildren will be able to draw off of this trust. And if they earn $20,000 in 2020, they will get another $20,000 from the trust. If they earn $100,000, they will get $100,000 from the trust. In other words, it was designed to encourage them to be productive, to not be, to just take the inheritance and be lazy. So that was an interesting thing. We've done that a few times actually. Sometimes the catch is that it's only used for college. That can be challenging because, well, what if they don't go to college? What is college defined as? But we've written those up a number of times so that we make sure that we're doing that. But again, it's not all of these ones when it comes with a catch. It's actually very challenging to draft because we've got to think of every possible scenario. One of the things, the last thing you want is something that is unclear or creates a situation where the money can never get out of the trust or things like that. So we've done them lots of times. It's just something that we have to be very careful about, very precise about, and we always give people help in coming up with the exact rules that they would want to do with that. But I've seen this on TV shows and movies and things like that, so that's always interesting. Okay, this is the one I wanted to. This is the one I laugh about. So you may have never heard of the rule against perpetuities if you didn't go to law school. So I was thrilled when I heard, or I saw this movie actually, that there was a movie that centered around the rule against perpetuity. So this is just kind of a joke among lawyers and law students, in particular law students, because this is actually a rule. And let me see if I can say it off the top of my head. We had to memorize this in law school, but it was something to the effect of your legal document must end, like a trust or a will, end, everything must be distributed out within 21 years of a life in being. So what does that mean, a life in being? So under the traditional, and there's lots of different variations on the rule against perpetuities, but on the traditional rule against perpetuities is there was, it says 21 years after a life in being, meaning that the way that how you calculate this is everyone on the planet Earth living and add 21 years. So if someone's alive that was alive, at the time that this legal document was drafted, that the trust can last and can hold the assets for that period of time plus 21 years. So everybody on Earth, let's say we signed it today, everybody on Earth has died, and then another 21 years, and then we'd have to distribute out whatever's left over in the, so that could obviously be 100 some years because people live for 100 plus years. Sometimes they did a variation on the rule against perpetuities that said 99 years and then 21 years, just to make it a little bit easier. But I think that, and this comes from Old English law from 500 years ago, but I'm pretty sure, I'm actually fairly convinced that they created this rule just to torture law students, because this would always be on our law student exams in real estate classes in particular, or trust classes, things like that, because they could come up with all these variations, all these tricks, and all these things, and it just was one of those things that law professors torture their students with. In Michigan, interestingly enough, they've actually gotten rid of the rule against perpetuities. So technically, we could have assets in a trust longer than that period of time. In other words, we're setting up the future generation. So let's imagine the Rockefellers or somebody like that, or the Hiltons, and they say, okay, well, we want to set aside this money and have each generation for the next 7 generations all get some money. They could do that in Michigan. Interestingly, there was a case out of Saginaw. So anybody knows about the history of Michigan, many, many years ago, Saginaw was actually a boom town, and because of lumber. Okay, so there was a lot of, actually, for that time period, rich people that lived in Saginaw. And in fact, I think most of them are gone now, but I used to live in Saginaw, and there was these mansions right along the river, and they were old mansions, that had been there for a long time. And Saginaw's not usually a place where you would see mansions, but they were from the lumber barons. And so one of them, and I can't remember the name. I used to know the name off the top of my head, but there was, I can't remember the name. He had set up one of these trusts where it was going to pay out money to future generations. And so it got to the point, because at the time that he signed it, there was a rule against perpetuities in Michigan. And so it got to the point where whoever his lawyer was, they drafted it into the rule against perpetuities, and he lived in 18 something, And this was just a few years ago. This was probably 2005, somewhere in that range. And the final money was going to get distributed out of this trust that had been going on for over 100 years, well over 100 years, I think. And so, interesting. So this is where I found it interesting. Not everybody finds this stuff interesting, but there was articles, and it made national news, and there was certainly a local in the local news saying how awful this lumber guy was, because he must have just hated his family, because instead of leaving it to his family that he knew, he left it to people 125 years later, and that he must have just been this miserable old man who hated his family. And that's what the article said. I mean, it was really very clearly that was what they were arguing was the case in this, and that's not the case at all. In fact, if you look at the history of this particular lumber baron, he provided very well for his family. Had a ton of money. Lumber was a huge industry here, and so they had a ton of money. He left lots of money to his family that was living at the time. He left lots of money to the next generation and the next generation, the next generation. It was just that much money that he could grow over time and everything else. And so the news media sometimes gets things wrong, right? They definitely got it wrong here, because they were. Yeah, I saw it on international, like I think on some The Economist or BBC or something. Some international news source was referring to this guy and how he must have just been really hateful because he didn't leave money to his own family, his living family, which wasn't true at all. They hadn't done the research, because the fact is that he actually had set it up for many generations to do this. And that's actually what happened in the George Clooney movie, The Descendants. This is actually, there was two things that I found interesting about this movie. One was that it was set on Hawaii, and there was this historic land, and his family owned this historic land, and he was an attorney, and he was the trustee, and it had gotten to the point where the rule of against perpetuities said it had to be distributed out, and they had to decide to sell it or keep it. And there was all these descendants now. It was probably like 100 people or something, because it was over 100 years later. And so then the story, there was lots of details in the story that were side stories, but that was basically the point of it, was that this very valuable land had to get distributed out. So that was one thing I thought was interesting, that there was actually a whole movie about the rule against perpetuities. The other thing I thought was interesting and makes me want to move to Hawaii was that, and this bears out, actually I have a friend who practices in Hawaii, but that the lawyers there are very casual. People wear Hawaiian shirts and shorts, and that's you don't go into a lawyer's office and see everybody in suits and ties. That's extremely common there, that they rarely actually put on a suit and tie for the law offices there, and I thought that was kind of fun. So, all right. This one's a good one. So I picked out, there's lots of movies like this, but this one in particular, the Aristocats Disney movie, and leaving money to a pet. So certainly. Now here's the thing. Some people laugh at this, but you can't technically leave money to a pet, right? You could leave it to a trust, and then the trust is managed by a person or a trust company or something like that, and set out the terms of the trust to say, this is to care for my pet. This is particularly a good idea if it's an expensive pet, like a horse. Sometimes people don't consider horses pets, I guess, but the bottom line is the horses are very expensive for housing and feeding and everything else. And so when I have somebody that has a horse, I often do recommend that we set up a part of the trust, as sometimes people call them pet trusts. And people do this with their dogs and their cats and everything else. Now, I've never had a client that went too overboard with this. I've had clients leave, $100,000 sometimes to make sure that their pet. Now, what it typically is, we do a couple of things with that. One is we say, okay, we're trying to figure out how much money it would be, but we put some rules in there, because what happens after, what happens if the pet dies? And so the thing on that is, sometimes people would draft it to say, okay, well, this person's going to be taking care of the pet. The money's going to go to them so they can take care of the pet. And then, but what if that person isn't such a good person and they take the money and then put down the pet? And so usually we put in some kind of rule that says, okay, this money is set aside for this to cover this period of time, but if the pet dies, that person doesn't necessarily get the money. In other words, we want to make sure that they don't have an incentive to off the pet. So there was actually a pretty famous story. This goes back. This is I don't know. I'm guessing this was the 90s. Leona Helmsley. Anybody remember that name, Leona Helmsley? She was she owned hotels in New York. She owned a bunch of hotels in New York, and she had a lot of money. And she left the bulk of it to her dog, or not really, to a trust for her dog. And that was made, you know, really a lot of, it was in the papers a lot at that point to say, oh, and people didn't like Leona Helmsley, I guess. There was a lot of bad stories written about her and saying that she was mean or, you know, whatever. And so this kind of fed into that she, you know, pretty much left everything or a huge sum of money, like $250 million or something like that, to care for her dog. And so here's the other side of the story. So a judge actually threw that out. Now, I don't know about the legalities of that. It seems like if somebody wants to set up a trust and they say these are the terms, they should be allowed to do that. But the reality, what actually happened is a judge reformed it after she died. She, in other words, changed her wishes and said, well, we're going to set aside this amount of money for the pet, and then we're going to do something else with the rest of the money, which, you know, seems not seems odd, but I guess everything has, you know, a good faith provision in it. So there must have been some argument as to why that was legal, but the judge did take it into their prerogative, and the dog apparently didn't have good enough lawyers to be able to keep the entire 250 million. So that's kind of an interesting one. Oh yeah, so I threw in a couple of these, and there's lots of stories like these. So Ghosted Mrs. Muir and Cat on a Hot Tin Roof are both about all the problems you cause by not having a will or not having an estate plan. And in particular, in one of these was you know, having a business and not having an estate plan, or having a blended family where it's you know, a second marriage and you each have your own kids and not having an estate plan. And so I threw those in there because there's lots of movies about that and all the problems that causes. So I hope this was a little bit fun for you. I was just trying to go through some of the big topics that we see in movies. Of course, the big one that we always kind of chuckle a little bit about is the whole concept of the reading of the will. But I thought there was other things to learn from those. So I don't know if we have any questions, Savannah. Doesn't look like we do.
No, you are correct, Bob. There are no questions at this time.
Savannah, we can hardly hear you. You're real quiet.
Is that any better for you, Bob?
Yes, very good. Thank you.
Okay, great. So there are no questions at this time.
All right. So if you want, we always are going to end with a request that if you know anybody that can use our help, Savannah will give you some instructions about what's the best way to do it. Or if you just have any questions and you want to check in with us, we've got a process for a free 15-minute sort of check-in or interview, and Savannah will tell you all about that.
Thanks, Bob. So yes, and also thanks to all of you for joining us today. I personally love this webinar. I thought this was really fun and I learned a lot today. So I look forward to sharing this webinar with family and friends. And do remember that you will get the replay tomorrow. It will be emailed to you. So if you think that someone will enjoy this webinar, then please feel free to share that email with family, friends, or anyone who you think could benefit from what we learned today. Now, also, as Bob mentioned, we do have an easy way for you to get started working with our team. You should have an email coming to you any minute now. I'd say maybe within the next 5 or 10 minutes, you'll get an email from me, and it will have instructions on how you can schedule an intake call with our Client Services Director, Katie. And during that call, You can ask her questions about our process, how things work. She'll ask you questions about your concerns and just your situation, and we can make sure that we schedule your appointment with the correct attorney and that we have a good understanding of what it is that you're coming in for. So I do encourage you to check your email and just go ahead and take a look. You'll actually choose a day and time that's convenient for you right there through the email, and Katie will give you a call. So thanks again for joining. That's all for today. We will see you next week at 2 p.m. Have a great day.